Mistake number 4. Spending your money on bond when you can't afford it. Somewhere out there, a grandmother is desperately searching the yellow pages so that she can bail out a family member tonight. In her devotion to bring a loved one home, it will never cross her mind that getting the inmate out of jail could be the worst possible thing to do in the case. This concerned grandmother will gather pay stubs, titles, multiple forms of identification, recruit half of the neighborhood to act as co-signers, and rush straight down to the bondsman. She doesn't know if she'll get her money back, how much money she'll have to pay, what her obligations as a surety are, and whether this is a loan or just a third party processing the bond with the court. Maybe the bonding companies can explain the process, but maybe they aren't the best people to ask since they are the ones about to receive this fast cash. Bail is the temporary release of a criminal defendant before trial. A bond is an amount of money in cash, property, or financial instrument posted with the clerk to make sure that the defendant attends all required court appearances. Bond allows an arrested person to be released from jail until the case is completed, whether through trial, plea, or dismissal. There are several different kinds of bonds. With a cash bond, a customer goes to the clerk's office and pays the entire bail amount. If the defendant bail amount is $5,000, then the customer pays $5,000 to get the defendant out of jail. No bondsman is involved. As long as the defendant makes every court appearance until the case is completed, the customer will get the remaining money after court costs and other fees. Cash bonds are rare because few people can afford to pay the bail amount in full. With a corporate bond, a customer goes to a bondsman office and pays approximately 10% of the bail amount to the bondsman. If the bail amount is $5,000, then he or she pays $500 to the bondsman. This is a contract between the customer and the bondsman. So the customer doesn't get this money back even if the defendant makes all of the court appearances. The bondsman will post a bond to the clerk's office and commit to being responsible for the total bail amount of $5,000 if the defendant does not appear in court. If the defendant goes on the lam, the bondsman will probably hire a bounty hunter to find and return the defendant to jail. If the customer does not pay as agreed, the bondsman will probably sue the customer and all of the co-signers in the civil court. A corporate bond and loan is the same as the corporate bond, except that if the customer cannot pay 10% of the total bill amount, they pay a lesser percentage and enter into a higher interest loan with the bondsman for the remaining amount of the 10%. If the customer can pay 5% of the bond, he or she might pay $250 to the bondsman and receive a loan from the bondsman for the remaining $250. Once again, the customer makes payments, doesn't get any money back, and may get sued if he or she doesn't pay the money as agreed. Nobody wants to leave a friend or family member in jail, but think about the big picture. Defendants need to worry more about the next 3 years, not the next 3 weeks. Before bailing someone out, ask yourself whether you can really afford to do it. Are you going to scrape the money together and then not have anything left for the legal defense? If you have to choose between a bond and an attorney, you need to focus on the attorney. Family members will often help a defendant get out of jail, but they may feel that getting an attorney is up to the defendant. While the family has good intentions, they do not realize that they are disqualifying the defendant for a public defender and setting him or her up for a very ticked-off judge who wants to know why the defendant has access to money to bail out of jail but can't pay for an attorney. For repeat offenders, the judge may ask why the defendant always seems to bail out of jail when he or she is arrested, yet owes $2,000 in unpaid fines and court costs. If a defendant bails out of jail, he or she will have follow-up court dates to report back to the judge about who has been hired for an attorney. This court date might only be 2 weeks away, so the defendant doesn't have a lot of time to get it together. Getting a lawyer rarely seems to be the first priority of the recently released defendant. Instead, he or she is eager to forget the terrible jail experience, and dealing with the offense often seems too overwhelming. However, when the defendant keeps going back to court to tell the judge that he or she still hasn't hired an attorney yet, the judge will usually revoke the defendant's bond, which means that the defendant can end up right back in jail anyway. Now the family has completely wasted their money, and they still owe more money to the bondsman. Instead of helping financially to hire an attorney, the family must now honor the former bond agreement to avoid getting sued in civil court. Revoking bond. There is no guarantee that a defendant who is out on bond will remain out of jail until the conclusion of the case. There are a lot of ways that the defendant can lose his or her bond, such as missing court, being late to court, getting new charges, or not complying with pretrial probation requirements like checking in, filling out job applications, passing a drug test, etc. If the defendant isn't acting right or doesn't have reliable transportation, the bond will not last for long. For the defendant's family. If you are considering bailing out a loved one who has a substance abuse issue or who is likely to reoffend, you should know that any new charges received while a defendant is out of jail on bond will 1. Result in the bond getting revoked, and 2. The defendant being sentenced consecutively, one after the other, on the current and new charges. Sometimes the toughest, smartest decision you can make is to let that person remain in jail and focus on obtaining good legal representation for them. For the defendant. If you are in jail, but your family hires an attorney, the attorney may also be able to get your bond reduced at a later time. In addition, you will have instant access to legal advice before you say or do anything boneheaded that makes your case worse. Your attorney can begin to lay the groundwork for legal remedies such as getting evidence thrown out or cross-examining witnesses, which could be lost if you wait too long to get an attorney. Whether you are in jail or out of jail, you're always better off having an attorney that is already working on your case. You may wonder how your family can hire an attorney if the defendant is in jail. The right attorney will be happy to meet with the family, accept the money on behalf of the defendant, and visit the defendant in custody. In these situations, the attorney must remind the family that even though they are paying for the defendant, they are not the client and do not have any influence on the case. The attorney should only work with the family if the family understands that the attorney works for the client. If a defendant cannot afford either a bond or an attorney, then the court will provide an appointed attorney. Some defendants gripe about getting a public defender based on the belief that these attorneys will not have the time to handle the case adequately. However, in many misdemeanor cases, these defendants spend a few days in jail, have their jail fees waived, and receive a time-served offer or even get the charges dismissed. If defendants are in this financial situation, it would be better to just tell the judge that they need the public defender rather than bail out. Now need a private attorney and be set up to fail. Bond and preliminary hearings. It is extremely important to understand that if a case is set for a preliminary hearing and the victim or witness does not show up to testify, the charges can be dismissed and the defendant can be released. In that situation, the defendant can be released without ever having to even pay bail. I often tell limited income families who do not believe that the witness will show for the preliminary hearing to consider waiting until after the hearing to bail out a family member, in the hopes that the bail amount will be reduced or completely dropped. Also, the hearing will be scheduled more quickly if the defendant remains in jail. If the attorney makes a motion to dismiss the case because the witness does not appear for the preliminary hearing, then the bond will end with the case. This means that the family will have to pay the bondsman again when the case is indicted into criminal court. These families often say, "Please do not make a motion to dismiss the case, because then we will have to pay another bond again." The attorney's ability to raise the pain level for the prosecution is therefore limited, and the defendant often waives the preliminary hearing just to keep from losing the bond. Now that the case will go automatically to the criminal court instead of being presented to the grand jury.